Hello, I'm 𝗏𝘕𝘂𝗋𝗇, founder of Starlit Contracts, where we help you to negotiate and use contracts with confidence. This video is part of our Build the Foundation in Contracts program, and our topic is intellectual property rights. So what is IPR? Well, the term is used to describe many different types of thing, such as trademarks, copyrights, and patents. How does IPR work in practice? Well, protection from IPR can either arise automatically, or it could be that you need to register your intellectual property rights. So for example, with a patent, it's something that you apply for. A trademark, it's something that you register. If you're the owner of IPR, there's often some commercial value of it to you. So if there's a third party who would like to use your IPR in some way, it would often be the case that the owner of that IPR would only permit someone else to use it or to access it if they're paying a certain fee. Additionally, if two people are entering into a contract, perhaps there's no established IPR at the time that they enter into the deal, but they might both be bringing content into that deal and working on it together. If there's a creation of some IPR or something that's capable of being patented or capable of having a trademark attached to it, then the parties can agree in the contract who should own that IPR if and when it's created. Is this something that you should care about? It depends entirely on your deal. When you're entering into a contract, is it possible that you'll create some IPR as a result of your interaction with the other party? Are you transferring any sensitive information that perhaps has IPR protection? Do you expect the other party to be paying for it? If the answer is yes to those questions, well then you would want to address it in some sort of way with your contract with the other party. If that's not the case, then you potentially don't need to address it. Let's look at a practical example together now. 𝗏𝙗𝙘𝙘 Supplier Limited enters into a contract with Background IPR Trading Limited. They agree to work together to combine suppliers' 𝗏𝙗𝙘 with Trading Limited's IPR and to see what they can jointly create. The result is a new invention with great business potential. So what can go right for the parties in this situation? Well, first and foremost, the most important thing is that the parties sat down before signing the deal to say, well, what happens with the things that we're bringing into the deal if we create something new together? Who should own it? Should any compensation be paid? Because if the parties pre-agree on that and set it out into the contract, then it should avoid disagreement later. So in this case, the parties could have agreed that Trading Limited would continue to own the intellectual property rights, the IPR, that it brought into the deal, that so-called background IPR. Given that the parties combined their resources to create some new intellectual property rights, the parties could agree that the supplier would own that. But because the supplier is getting that benefit, they would also be under an obligation to pay a pre-agreed sum to Trading Limited in full and final conclusion of that transaction. So both parties get a positive outcome and can leave the deal happy. What could go wrong for the parties in this situation? Well, if they hadn't come together prior to entering into the contract to agree how they would want to manage any newly created IPR, then when they entered into the contract, assuming the contract is silent on this point, then having created some new IPR and the parties seeing that there's some commercial value to it, it's much more likely that there's going to be a disagreement between the parties about who should own that IPR and who has the right to commercialize it. Now this could either end up in a dispute, or the chances are that Supplier Limited would have to pay a lot more in the way of compensation to Trading Limited in order for Supplier Limited to have the sole use and ownership of that IPR. We'll look at a sample clause and some key considerations together now, and firstly to the definition of IPR, which means intellectual property rights that are owned or licensed, whether registered or not, and includes inventions, trademarks, copyrights, patents, trademarks, and know-how. And now to the clause. Each party retains exclusive ownership to its IPR. A party may only use the IPR of the other party to perform its obligations and for use of the equipment or the service or the works, whatever applies in your contract, in accordance with the agreement. Our first consideration is to look at the definition of IPR. Does it address the types of IPR that you need to take into account for your deal? Or maybe there's more in this definition of IPR than you really need for your deal, and you can amend it accordingly. Our second consideration is whether the customer would need a license in order to use the works that have been provided by the supplier. In some cases they will, in some cases they won't. But if a license is required, then a supplier should be taking into consideration, would there be any additional fee for the customer to pay on a monthly or yearly basis in order for them to use that license? If a customer does not need a license in order to use the works which are provided by a supplier, then in many cases this clause would be sufficient. Our sample clause continues, any new IPR that may result as a direct consequence of performing the agreement will be owned by or be transferred to the supplier or the customer, whatever is agreed between the parties. In such case, the supplier-customer will pay customer or supplier a sum of, and then you insert the value, as full and final compensation. This type of clause or a similar mechanism can be very helpful when you've got a research and development agreement, or when you've got two contract parties that are coming together to try and create something new, something innovative. It probably isn't needed in most cases when you just have a normal sale agreement. When you have maybe an off-the-shelf product, you're sending that to the customer is making a payment for it. The customer's not actually contributing anything to the creation or the development of that product. So in those circumstances, you probably wouldn't need the clause. I hope you found this introductory content helpful, but if you're ready for the next step to learn how to negotiate and use contracts with confidence, then check out our website starlitcontracts.com, where you can become a member to access additional content, interactive sessions, and be part of our community. I look forward to seeing you there.